She's too like, I know you heard what I said.
All right, guys. So that is actually where all the coverage of the testimony ends, unfortunately. It's all the cross examination we get to see. But as you can see, the prosecutor's theme of the cross examination is that he's capable of lying. He lied to the police. He's lied about the circumstances. He was lying about different facts and circumstances surrounding the case. So as a result, and he's making self-serving lies. He's leaving out details that are self-serving to himself. So as a result, the judge shouldn't trust him. Now remember, this is a situation where a judge is going to make the final determination on, what the verdict will be. It's not going to be a situation where a jury gets the decision here. So I think that's why the judge was kind of stopping things and getting a little frustrated, because it's like, listen, I'm the one that's going to be the trier of fact here, so you don't need to go with all the dramatics, and you don't need to. And I think that's what the commentator, I'm not playing that in full, but the commentator there was also saying that, listen, this prosecutor was being too dramatic and emphasizing things. So next, unfortunately, like I said, this is where the coverage. We don't get to see closing arguments or anything like that. The next thing that happens, the next coverage of this case, is the verdict, and now understand this: when a judge in a bench trial gives a verdict, it's a little bit different than when a jury gives a verdict. Jury just simply reads the verdict. Count one, guilty, not guilty. Count two, the judge actually makes findings of fact that is in support of the verdict that she's going to find. So you actually get to hear the thought process behind the verdict when it's guilty or not guilty. So it takes a little while. So this will be about 20, 30 minutes of the verdict and aftermath. If you haven't found out what the verdict is yet, if you haven't seen it yet, I'm not going to spoil it. We're going to go in now, and we're going to watch the verdict now. Like I said, we're going to pick up now. Unfortunately, the coverage picks up where the is in the middle of the judge starting to recite her facts and her support of the verdict.
Charges contained in counts 1 through 3, there are also attendant firearm specifications. The state must prove beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing those offenses, and displayed the firearm, brandished the firearm, indicated that he possessed the firearm, or used it to facilitate the offense. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm that is inoperable, but that can readily be rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosion or combustible propellant, I may rely on circumstantial evidence, including but not limited to the representations and actions of the defendant while exercising control over the firearm. As to the charge of improper handling of a firearm in a motor vehicle, in case 2206-2276, the defendant must have knowingly transported or had a loaded firearm in a motor vehicle in such a manner that it was accessible to the operator or any passenger without leaving the vehicle, and the accompanying forfeiture specification of the Riley Defense, Inc., R8K 47, serial number B11765. I've carefully considered all of the evidence and the exhibits admitted during trial. I've weighed the credibility of the testimony of all the witnesses, including the testimony of the defendant. It is my province to believe all, none, or some of the testimony of each witness, as well as the physical evidence that has been presented and the exhibits admitted during trial. I have considered the physical evidence and whether it corroborates the testimony of each witness in deciding which, if any, of their testimony I choose to believe. I find there is no credible evidence that Ms. Westover threatened or even tried to harm the defendant. There was credible evidence that the defendant had hold of Ms. Westover either by, as to her upper torso, whether by her hair, neck, or shoulder. Ms. Westover was shot 3 times, and the most serious injury which caused her death was a gunshot wound to the back of her neck that was approximately 8 to 10 inches away and included evidence of stippling near the entrance wound, and the trajectory of that propellant was from back to front, right to left, with a downward angle. While the defendant's testimony at times was believable, and there were portions of his testimony that he seemed genuinely convinced of the testimony he was presenting, I find a majority of that testimony was completely self-serving, illogical, and completely uncorroborated by the physical evidence and exhibits admitted during trial. In reviewing Exhibit G of the defense's exhibits, there was no credible evidence that you were injured or that your clothes were torn by Mr. Cruz, the machete-wielding aggressor. While you fled the scene, both Adam Wright and Brian Fielders had already both fled, and you still possessed the firearm. Furthermore, once you dropped from the porch, you leisurely strolled away with no signs of panic or fear that you testified you were feeling during the trial. Your statements to detectives the night you were arrested contained various inconsistencies, not to mention were completely inconsistent with your testimony during this trial. Lastly, your actions in fleeing that night with Miss Westover's purse and the firearm, and changing your appearance and hiding out in your cousin's house for over a month shows a consciousness of guilt. This court is left to weave together the offensive events of July 25th, 2022 from all the testimony, the physical evidence, and the exhibits admitted during trial. Based on everything presented at this trial, the more logical sequence of events is that for whatever reason, including being high on methamphetamine, not having slept for days due to that methamphetamine use, and the paranoia that comes with the use of methamphetamines, you shot and killed Toni Westover. And after shooting her, you were attacked by Brian Fielder, and when you had him down on the floor, he bit you while trying to get the gun away from you and from your grasp. According to Ashley Bratton, who testified 2 times, and including yesterday, Adam Wright was on his way out of the back bedroom with a firearm and returned, and upon finding you on top of Brian Fielder, hit you with the firearm and then fled. Everyone fled through that back bedroom because Toni Westover was left dead, hanging over the side of that couch, and was blocking the front door. Therefore, I'm left with only one conclusion. The state of Ohio has proved beyond a reasonable doubt that you committed the crime of improper handling of a firearm in a motor vehicle on June 5th, 2022, and furthermore, by clear and convincing evidence, I'm ordering forfeiture of the Riley Defense, Inc. RAK 47. As to all the charges in the indictment in case 2209-3102, I have considered each count uninfluenced by my verdict as to any other count, and I find that the state of Ohio has proved beyond a reasonable doubt that you did not act in self-defense on July 25th, 2022, and that you were at fault in creating the situation, giving rise to the shooting, or attempting to shoot Toni Marie Westover, and or that you used unreasonable force against Toni Westover. Therefore, I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 1, and the 3-year firearm specification 1 to count 1. I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 2, as well as the firearm specification 1 to count 2. I find you guilty beyond a reasonable doubt of felonious assault, a felony of the 2nd degree, as contained in count 3 of the indictment, and the firearm specification 1 to count 3. And lastly, I find you guilty beyond a reasonable doubt of tampering with evidence as a felony of the 3rd degree as contained in count 5. The court having rendered its verdict, I am prepared to proceed to sentencing at this time if both parties are prepared also. Before hearing from the parties, I do find pursuant to Ohio Revised Code 294125, State versus Johnson and State v. Ruff, that counts 1, 2, and 3 merge for purposes of sentencing. I find that the defendant's conduct is of similar import and was committed with the same animus.